next case set for argument is State of Ohio versus Clarence Powell Jr. It's case number 18CA0048M. Each party will have 15 minutes to present their arguments. The appellant, of course, may reserve up to 5 minutes for rebuttal. Just let me know if you plan on doing so, and I'll try to keep you apprised of the time that you have remaining. The arguments are recorded, as you know, so we ask that you stay at the podium and keep your voice up. The court has read the briefs in this matter, and we are ready to proceed if you don't.
Yes, Your Honors. May it please the Court, my name is Attorney Joseph F. Salzgaber, and I represent Clarence E. Powell Jr. in this matter. This matter is relatively straightforward. Mr. Powell is arguing that the trial court erred and abused its discretion by sentencing him to the maximum jail term of 30 days without consideration of all the sentencing factors under 2929.22.
Counsel, was the term of incarceration stayed pending appeal?
Yes, it was, Your Honor.
Okay. Thanks.
As everyone I'm sure knows, that's once the jail sentence is served, the court loses jurisdiction in misdemeanor cases. So there was a stay filed, and that was granted by Judge Warner. In this particular case, Mr. Powell had been released from prison after a number of years. He does have a terrible record, I would acknowledge that. But he's now 49 years old, living in the Medina area with his daughter. He hasn't been in any significant trouble since his release from prison, and makes his living as an owner of a lawn care and landscaping business with numerous clients. The incident in question took place on February 1st, 2018, when he was stopped in a black Buick automobile. He did not have valid driving privileges, and he did not come to a complete stop at the stop sign. So he was charged with those offenses. Medina police were subsequently advised that he had been witnessed on the property of Union Square Apartments, where he had been banned some 20 years earlier in writing during his period of time when he was engaged in drug activities. He indicated he had forgotten that he had been banned, or that he believed that that had expired for some reason because it had been roughly 20 years earlier. But nonetheless, he was charged. He pled to all of the charges in both the traffic case, which ironically was more serious. The DUS case, driving under suspension case, was a misdemeanor of the first degree. He had served 1 day in jail as a result of his arrest back in February of 2018. Changed his plea in March of 2018 before Judge Warner. And in the PSI, there was a recommendation by the probation department that he get 4 or 5 days, I believe, for the criminal trespass case, given his prior history, and we acknowledge that he has not a good record. Nonetheless, the trial court, in imposing the sentence, did not consider all of the factors involved in this particular case. The victim in the criminal trespass case was Union Square Apartments, corporate entity. They were not harmed, I would argue, in any sense, any property sense. Mr. Powell had otherwise had legitimate reason to be there. He's no longer engaged in illegal drug activities. He has his mother used to live there, his sister and his aunt both still live there. And he indicated, and there was nothing to dispute that he thought this ban was no longer in effect, forgot about it. So based on that and the fact that the record is devoid of consideration of factors other than his age and prior record, we would argue that imposition of the maximum sentence was improper without consideration of all of the factors set forth in 2929.22. I would reserve the balance of my time.
We'll give you 5 minutes for rebuttal. You've got 15 minutes.
Thank you, Your Honor.
Mistake.
May it please the Court, I'm Bob Campbell, Medina City Prosecuting, Assistant Prosecuting Attorney. As the law reserves maximum sentences for misdemeanors, either if it's the worst form of the offense, or it reserves it for offenders whose conduct in response to prior sanctions or prior offenses demonstrate the imposition of the longest jail term is necessary to deter the offender from committing a future crime. Clarence Powell has been committing criminal offenses in Medina County for as long as I've been an attorney, which is 26 years. He has been sentenced to prison. He has been sentenced to probation. He has been sentenced to prison after having given an opportunity of probation. He's been sentenced to drug treatment.
My understanding though that this was 20 years in the past, has he lived
The,
a long?
the no contact order, the no contact request was 20.
What about his prior,
20
what was
years.
his most recent prior? criminal offense?
Most recent that I'm aware of, Your Honor, was a 2014 drug trafficking sentence or a conviction, felony, that resulted in a prison term. From reviewing the docket online, I did not see that a transcript of the sentencing hearing was filed. Am I correct on that? Does the court have a transcript of the sentencing proceeding?
You know, we have so many cases, I'm not
Okay.
sure, we'll
I
certainly
don't,
check.
I don't
that for-
believe there is,
Okay.
okay? So what happened between Mr. Powell and Medina Municipal Court on the day of his sentence, I don't believe is a part of the record. I also don't believe the pre-sentence investigation, which purportedly recommended only a short period of jail, if that is correct. I don't believe that is a part of the record either. I believe the only record that this court has to review is Judge Werner's sentencing entry. And Judge Werner's sentencing entry notes his, or Mr. Powell's career of crime starting in 1988. And that entry, to go back to your question, Judge Teodosio, indicates that in 2014, Mr. Powell was charged with failure to comply, lawful order of a police officer, which was a felony 3. It was a chase. And it resulted in him getting probation, violating that probation, and then serving a 2-year prison sentence. So he was released probably within a year of when this offense was committed.
Were any of his priors committed at the time that he was prohibited from coming onto the property anymore? Because I don't see any criminal trespassing here as a prior.
I don't know that he-
offense, but did something happen that, were one of these things precipitating no contact with property?
It's likely. That apartment complex has a lot of folks who receive federal funding.
But there's nothing in the record that would indicate.
There's nothing in the record of that.
Because none of them are criminal trespasses. None of them have anything to do with trespass.
That is correct. Counsel relayed the incident, this offense. Quite frankly, the reason anyone knew he was at the Union Square Apartments is because the Medina County Drug Task Force was surveilling the Union Square Apartments for drug trafficking activity, and they saw Mr. Powell. So there is no sanction available to a municipal court for a misdemeanor like Mr. Powell other than placing him in jail. He doesn't understand anything other than jail sentences. His history shows he responds to nothing other than jail sentences. And quite frankly, I guess a response isn't what we're looking for. A 30-year career, 20-year, 25-year career of crime, this person's not going to be rehabilitated at this point. The person, the purpose of the sentence is to be punished. And a 30-day jail sentence is, quite frankly, to someone like Mr. Powell, not a significant jail sentence. So the state of Ohio would ask that the court uphold, find that Judge Warner, based on this record, based on Mr. Powell's history, and the law did not abuse his discretion in imposing that change. Thank you.
Thank you. And you have 5 minutes for rebuttal.
May it please the court, in response to Prosecutor Campbell's argument, I would note that the transcript was filed with the court, as was a copy of the PSI. So that is part of the record. There's no disagreement that Mr. Powell has a bad record, and he was released from prison in 2016. However, in this particular case, he was given the maximum without consideration of the sentencing factors under 29.22. And in fact, he was given 1 day time served for a misdemeanor of the first degree, more serious offense arising out of the same incident. And the recommendation of the probation department was 4 or 5 days. So given those factors and the fact that he did not commit the worst form of the offense, he was at Union Square Apartments visiting family members. There's no hint or allegation that he was engaged in any sort of illegal activity at that time, other than obviously driving under suspension. So we would argue that the worst form of the offense has not been committed, and ask that this court reverse and remand for resentencing.
Very good. Was that a question, Judge? No? Okay. Thank you both for your arguments then today, and the court will take the matter under advisement, issue a decision in due course. The clerk of courts will certainly mail a copy of the decision to you on the day it's released, and you can keep an eye on the Supreme Court of Ohio's website where the opinions are also posted.
Thank you.
Thank you both.